Thank you, Mr. Chairman. I have a lot to respond to that popped up there. Just Mr. McClennock's final comments. No, this is not the next step that's supposed to be taken. According to the Supreme Court and court law that we discussed earlier, the accommodation process is the next process, the next steps to be taken. And as the chairman acknowledged in his responses to questions from Mr. Schiff, this committee hasn't done that, hasn't even initiated those sorts of conversations, either with the White House, the Department of Justice, or any other aspect of the executive branch. Furthermore, as you know, I think you did a great job of articulating why this is a conflict between the executive branch and the legislative branch. Why Mr. Zwanitzer gets caught in the middle of that, I think, has not been articulated, and at least not well, especially since all of the documents, all the information that the committee is seeking is in the possession of the Department of Justice. And as I discussed earlier, there's no effort that's been made by this committee to get this information from the Department of Justice. My colleague from New Jersey talked about going to the Department of Justice previously for information, but he's conflating Mr. Zwanitzer's material with the her report material. This committee did have a hearing of sort and did seek contempt with respect to the audio tape from the deposition that Mr. Biden gave, but there's been no effort to try and do anything along those lines with respect to this civilian who's caught in a conflict between, you know, two giants that are the executive branch and the legislative branch. And I got to say this too, you know, when we go down this path that quickly, it creates problems that don't need to be there. And I mentioned the January 6th subpoena a few minutes ago, and this kind of a scenario we had in the last Congress. Obviously, that was relevant. In fact, I think it goes to the heart of one of the cases that are the criminal cases that are standing against Mr. Trump right now. So we can't say that it's an irrelevant matter or that he's not getting his day in court. But the January 6th subpoenas went directly to the information about conversations had with the president and those members of Congress on that day and leading up to that day that were directly relevant to that day. Now, Mr. Klein's not here, but we've had this discussion before, and I know he would say, Mr. Ivey, they didn't just stiff the committee. They actually sent letters in response and raised privileges and objections to why they shouldn't have to comply with the subpoena. And at least Mr. Jordan did. I don't think Mr. McCarthy did. He just didn't show up for his deposition date. But the fork in the road occurs right there, because right now we've got Mr. Zwanitzer, who is trying to raise these kinds of rights and objectives and privileges. The White House raised its two days ago. By the way, Mr. Jordan responded to the January 6th report subpoena 2 days before he was supposed to show up for his subpoena too. So this last minute thing that was raised earlier does not permit us to go forward in this process as we are today. But in any event, rather than step forward and start holding members of Congress in contempt, as I guess would be what we were trying to do today, if the January 6th committee had treated this the same way we're behaving now, that would have been the next step, as opposed to trying to reach some kind of accommodation. At that point, it was referred to the Ethics Committee. But seeking criminal contempt is a big step that we're treating very cavalierly, very cavalierly. You know, we've got a constitutional obligation to conduct oversight, sure, but really? No accommodation process? We get a letter from the White House, and just because we got it, you know, a day or two ago, that means we don't have to try and deal with the issues that are raised in the White House letter? We don't even have to go to the Department of Justice, even though we know they have all of the information that we're trying to get from this private citizen. And the case law that I just read a few minutes ago says that's exactly what we're supposed to do, exhaust all other alternative sources for the information. This is not how we should handle the power that we've been entrusted by the American people in the Constitution. We just shouldn't do it this way. I don't know what the rush is. I don't know why we have to do the hearing and hold this private citizen in contempt today without even trying to take the steps that the courts have told us we're supposed to take. So, I think this is one where, you know, if you want to have a hearing, which is something that I would highly recommend, you know, give them a chance to present their arguments and their, you know, whatever privileges and rights they want to assert. They should have a chance to do it. We shouldn't be doing it on the fly like this. Like like he doesn't have a lawyer that's tried to respond. He sent us a written letter raising these objections 6 weeks ago.
Time of the gentleman has expired.